Welcome to The Explainer. Today, we are diving into a really big deal in the tax world, a landmark court ruling in India that's completely changing the game for multinational businesses. If you have any operations in India, you're going to want to stick around. We'll show you exactly what's changed and what you need to do about it. Let's jump in.
So let's kick things off with a big question. Can your company actually be taxed in India if you don't have a single physical office there? For the longest time, the answer was a pretty clear no. But as you're about to see, that has all changed and in a huge way.
All right, to really get what's going on, you've got to understand this one key idea: permanent establishment, or just PE for short. The easiest way to think about it is like a tax tripwire. If your business activities in India happen to trip this wire, boom, a piece of your profits is now on the hook for Indian taxes.
Now, for decades, the rules for this tripwire were super simple, right? It all boiled down to one main, very tangible idea. The old rule was just straightforward. Imagine that tax tripwire was a literal physical cable plugged into a fixed place of business. You know, an office, a factory, a branch. If you had one of those in India, you had a PE. If you didn't, you were pretty much in the clear. Simple as that.
Okay, but this is where the story gets really interesting. A game-changing ruling from India's Supreme Court has just completely shredded the old rulebook. It's basically made that physical tripwire invisible. Let's look at the case that turned everything on its head.
So the case in question? It's Hyatt International versus the tax authorities. This thing went all the way to the Supreme Court, and the judgment it handed down has sent massive shockwaves through every multinational enterprise that does business in India.
So, what's the new rule of the game? Well, it's a huge shift away from things you can see and touch to something way more abstract.
Okay, this slide right here is the absolute core of it. Look at this pivot. The old test was so simple, wasn't it? It was a yes or no question. Is there a physical place of business? But the new test? It's way more complex. Now it asks, is the foreign company exercising effective control and providing continuous direction over its Indian operations?
And this quote, it perfectly captures the court's mindset. They basically said, forget the paperwork, forget how the contracts are written, we're looking at what's really happening on the ground, the substance. It's not about what you say you're doing, it's about what you're actually doing.
So in the Hyatt case, here's what happened. The parent company is in Singapore, right? But they had their regional managers physically working from inside the Indian hotels, calling the shots day in and day out. The court saw that and called it continuous operating guidance. And that constant oversight from inside India was the absolute key.
And what that meant, in the court's eyes, was that the local Indian hotel wasn't truly independent at all. It was constantly being told what to do on everything: brand standards, who to buy supplies from, pricing, you name it. It couldn't make its own key decisions, which proved it was being controlled by the foreign parent.
And this, my friends, is where we get the idea of a virtual PE. That old tax tripwire? It's not a physical cable in an office anymore. Think of it now as an invisible Wi-Fi signal. An employee working from anywhere, a hotel room, a shared workspace, even their own home. If they are habitually calling the shots for the Indian business, boom, you've just tripped the wire.
Okay, so what? You've tripped this new invisible wire. What does that actually mean for your bottom line? Well, it all comes down to something called profit attribution.
Here's how it works. First, the tax authorities look at what your people in India are actually doing, the key business activities. You'll hear this called functions, assets, and risks, or FAR. Then, based on that analysis, they basically carve out a slice of your company's global profits and say, this part was earned because of the activities in India, so it's taxable here. It's a huge deal. All right, let's get down to brass tacks. This is probably why you're watching. Given this whole new reality, what practical steps can you take, like right now, to manage your risk? Here's your action plan. First up, your legal framework and your governance. You've got to review all your intercompany contracts. Make it crystal clear that your Indian managers report to Indian officers. And your board minutes? They need to scream autonomy, showing that the Indian entity is making its own decisions. Next, you need to think about your day-to-day compliance. Start paying attention to your digital footprint. Where are those emails with the big approvals coming from? You absolutely have to start doing annual PE risk assessments and make sure your transfer pricing documents are bulletproof. For real peace of mind, you might even look into an advanced pricing agreement. And hey, a quick heads up. If you're in IT, consulting, or you run one of those big global capability centers, businesses where foreign and local teams work hand in glove,
You are in the hot seat. For you guys, this is not a wait-and-see situation. The time to act is now.
Look, this ruling is a massive shift. We've gone from looking for physical buildings to looking for signs of effective control, and it forces every single multinational to end with this one really critical question. In our world of remote work and globally integrated teams, is our virtual presence in India creating a very, very real tax liability?